with over 35 years experience. So we're excited to show you this, and I'll just start by showing you the agenda. This is what we're going to do today. We'll just step right through it. And the first thing on the agenda, though, is to introduce you to the speakers. And like I said, I'm Jim Hallenbeck. I'm the president and CEO of Black Hills AI. I'm a U.S. patent attorney with 21 years experience. Okay, well, Tom's here somewhere, but Tom is our CTO. He's a U.S. patent attorney, and he's been with Black Hills for quite a while. I'm sorry, I'm told my audio is fading in and out. I apologize for that. Let me switch my headsets. Okay, I'm hopeful that you can hear me better now. Thank you for letting me know.
Yep. Jim, this sounds good.
Okay, very good. Sorry about that. So, okay. I'll introduce myself real quick. My name is Jim Hallenbeck. I'm the president and CEO of Black Hills Black Hills AI. I'm a U.S. patent attorney with 21 plus years experience. And Tom, why don't you introduce yourself?
Sure. Hey, so thanks, Jim. I'm the CTO with Black Hills AI / Black Hills IP formerly. I'm also a patent attorney. Geez, I've lost track of the count, but probably 20, close to 19, 20 years now. Geez. And work with our technology group here at Black Hills.
Very good. And like I was saying earlier, maybe it was cutting in and out. Our work product from our Otto tool is produced by an attorney with a hidden identity. He has over 35 years experience in active preparation and prosecution practice. And he is still currently actively practicing. So we're going to compare the output of our Otto artificial intelligence tool to that of the hidden identity attorney, and we'll just see how it goes. And why don't we go ahead and get started? Okay, so Otto is your virtual legal aid armed with a deep knowledge of patent law, including statutes, regulations, the MPEP, industry best practices. It has even more capabilities than that. It's been trained with forms and legal writing abilities. It makes it your go-to resource for a wide range of legal tasks, even beyond patent law. And it has a high general knowledge as well, as with many AI tools. It's quite a useful tool for many things. So when you log into our tool, into Otto, the first thing you see is our starting page. And on this, there are different skills that can be presented. You can use these skills. A skill is essentially a stored set of prompts that you can use. And you find a prompt that you'd like to achieve a certain task, you can store those. That capability is soon to be expanded with something that is being called playbooks. And we will have more information on that in the near future. But we're really excited about the additional features that we're going to be added to the tool as well. So more exciting things to come beyond just what we're talking about today. But we'll show you some of these as we go along. But just to familiarize you with the interface, this first interface here, we have our stored skills here in the middle. And on the left, these are different sessions. And these sessions exist as long as they're sitting here. When you mouse over them, you can get an X. And if you want everything in there to go away, you click the X. It deletes it, and it's obliterated from your history. And the data is completely deleted. Anything that you enter into our AI tool is contained only within your session. It's not shared with anybody else. It's not used to train anything else. The information in there only influences the chat within which you are currently participating. So this is built with, I believe it's Type 2 SOC 2 security, and it's very hardened, and there's great privacy and data security built into it. It's a very robust tool developed specifically for use in US patent law. So we've also taken into account export control, and we contain data within servers that are only in the United States.
And
so
Jim, I think it's also worthwhile to point out too that all of the development of this tool, the skills, the playbooks, have been overseen by folks like Jim and myself, so patent attorney based, from the perspective of, is this tool going to provide useful outcomes for somebody that's practicing? And that's not just, can it do something interesting, but could I put this to use in my own practice? So
absolutely right. And when you have questions about how to use the tool or how to implement it within your own practice, those questions can come to Tom and me and other members of our team that are very skilled and experienced in patent practice, and we're able to help you develop those skills and those prompts that you need, or share with you prompts that we have, but also know the context within which you're trying to use them. So it's we're pretty well adapted to meet the needs in patent practice. So why don't we go ahead and continue? I've selected a skill here, but this is the skill that I specifically set up for this task, or for this showdown. This is a listing of the things that we're going to ask it to do as we go. So this is the interface. Over on the right, you would enter your message or your prompt that you want to ask it. If you want to upload a document to be able to ask questions of the AI tool of Otto about your document, you can click upload and ask those questions. You can also ask it to compare documents. You can ask it to create claim charts. You can ask it to do a lot of different things, and the limit on what you can ask it to do is really only the same boundaries of your own imagination and your own thoughtfulness and how you might implement such a tool. So continuing it on to talk now about our showdown and how we've set this up. What we did is we generated an invention disclosure from a published patent application. And then we provided that invention disclosure to our attorney of hidden identity. And we asked that attorney to take approximately 2 hours to perform some tasks. And then we tasked ourselves with the same thing using Otto, and we want to compare the results. And then we also have some time factor information about how long it took, so we can compare time as well. So the source of the disclosure is, it has this serial number, this publication number, and it deals with processes for generating audio books with appropriate genre appropriate voices, and doing it in an automated way rather than having people read it. We're using the process uses it's a logic-based, AI-based type audiobook generation system. So the invention disclosure looked like this. It included a flow chart, various information, details on how the invention is implemented, and what the problem is, and what the key advantages, and so on. Very similar to the type of invention disclosures that you get when you're in private practice, and that you receive maybe a draft from them, or maybe you send them out to outside counsel if you're in-house. So from that, we'll go ahead and start our showdown. But before we get into the details of the showdown, what we're going to do is we're going to just look at 2 claims. And one of these claims was drafted by a patent attorney, and one of them was drafted using Otto, our AI tool. So we have a poll to put up, and if you could take a look at that claim and take a look and see what which claim you believe to be drafted by AI. And Sydney, why don't you go ahead and put up that poll now? Let's see. All right, there's the poll. Okay. That's interesting. All right. Getting quite a few results. It's slowing down a little bit. Go ahead. We'll give you just a few more minutes. Tom, did you have any thoughts here? No is an acceptable answer. I just don't want to be the only one talking if I don't need to be. We'll give it just a couple more minutes here. We have 79 responses so far. And the belief...
This was tricky when I looked at it the first time, trying to call out and figure out, what looked like a mechanical response versus where there might be, kind of more human generation. And I've got a comment that I want to add, but I'll bring it in after we see the results.
Okay, so why don't we go ahead and end the poll? And I'm not going to review. Well, go ahead and end the poll. I didn't want to review the. Let me write down the answers. Or this is 26 to 55, A and B. Okay. All right. Cool. Let's hold off on sharing the results if we can. But go ahead and comment, Tom.
Did you mention that the attorney version is in a draft state?
The attorney version is in a draft state. The attorney that prepared this took 2 hours and did not complete all the tasks in the time that we asked them to take. So, this was likely a claim that would be drafted in advance of a examiner interview, or I'm sorry, not examiner interview, an inventor interview, to learn more details about the invention. So, the fine tuning of the claim by the human attorney would have taken place at a later time. So, so that's that. Something to keep in mind too. So maybe I should have disclosed that in advance. But that being said, we'll reveal later which one was which. Let's see. Okay, so let's look at the next slide here. So we're going to go ahead and start the showdown. We're starting with our user interface in a base state, and then we're going to go ahead and ask it to generate 5 questions about the invention that an attorney might ask to elicit greater detail about the invention. And you'll see that the AI tool came up with some pretty good questions, pretty quickly. This happened, you enter this and it comes out within a matter of seconds. It's very quick, very quick. And so rather than, these are reasonable questions, how extensible is the system to generate or to new genres and types of books beyond what was tested initially? Asking for more details about the machine learning models and so on. So let's go ahead and take a look at what the human attorney generated. And this is a very robust set of questions that an attorney would prepare before going in to talk to an inventor. Quite detailed. I would say that these questions compared to what the AI tool generated are much more detailed, but with the caveat that I only asked for 5 questions. So, keeping that in mind, but the attorney would have taken quite a bit of time to come up with this set of questions, and would have actually required the attorney to read the disclosure in advance, which, and read it in detail to come up with this set of detailed questions. Now, the goal of this AI tool isn't to replace the attorney, it's to augment the attorney's skills. And so, and augment the work product to make the attorney better at what they're already doing and enable them to do it faster, increase the productivity. So, just keep that in mind. So what we did next was we said, okay, well, let's generate some more questions. And you'll see that this is a full set of 15 questions. We asked it to generate 10 more questions, 15 questions in total. And I find it quite interesting here. Like, so say, for example, you look at question number 6, what methods are used to determine the optimal boundary points for splitting the text into overlapping subsets during processing? Let's switch back to what the human attorney generated. And let's look at question number 2. When processing subsets of book text, ensuring continuity by overlapping text portions, what is a subset, what is overlapping, and quantity of an overlap? And so you start seeing that the questions start ending up in about the same place when you ask for a larger number of questions. And so when we use an AI tool, what we can do is we can ask for maybe more than we need, and then we can use our experience, our knowledge, and so on to ask for a larger set of more than what we need, and then call that with our knowledge, experience, and so on. And it happens very rapidly, very rapidly. You're talking a matter of seconds, certainly less than a minute. And but to get to that same point as an attorney, to get that set of questions, it's going to take you quite a bit of time. Now you're going to add some additional time to cull through it, but it's going to happen very quickly. And it's quite likely that you're going to come up with questions and angles of approach to the invention that you were not going to be able to come up with on your own in the amount of time you have available. That's limited not only by your schedule, but it's also limited by the amount of billable time you have to work on a matter. And the more time that you save on the front end, it's the more time that you have to use on the back end to generate a better quality patent application. So from that, let's go into drafting a method claim. Here, we simply asked the AI tool to generate a method claim. And then we asked the attorney to do the same. And then that gets us to the point of doing our reveal. And let's share the results. I clicked on the button. You'll see that claim A, according to the poll, was considered to be the claim that was drafted by a human, and claim B was considered to be the claim drafted by Otto. And when in reality, it was the opposite. Now, keep in mind that claim B was a draft claim. It wasn't a final claim that you filed in a patent application. But I think this highlights, this is like, I didn't think the poll was going to come out like this. I thought it would come out with, but I'm also not, I am surprised, but I'm not surprised at the same time, because the AI tool is really good about getting antecedent basis issues right very quickly. Yeah, and it's pretty good, and it's been trained with modern practice. That's one of the things that Tom and I were talking about, is the idea that this claim A includes by one or more processors, which many attorneys use when they're drafting in the computer-related arts these days in view of 101 practice. And Tom has been in active practice of doing drafting and in prosecution for I don't know, you think you've been at Black Hills for about 7 years now, right, Tom?
Yeah, that's right. So I was looking at that and saw, oh, this looks a little bit different than I've been used to drafting computer implemented claims, say maybe 10 years ago. So I was keying in on that, but of course, this is a kind of more modern practice, one that the tool would have learned from or from the training in its machine learning, which is pretty cool. Basically, being able to stay up to date with what our current best practice is in that respect.
Mm-hmm. Mm-hmm. Yeah. So so that's quite interesting. That's where we ended up with our poll. So I'll stop sharing that poll now, and we will move on from there. So yeah, it's quite interesting. So why don't we move on to the next slide here? And keep in mind, this AI tool is not intended to replace an attorney, because I'm sure that you've all heard stories about where people have used AI and gotten themselves in trouble because the AI tool hallucinated and generated generated, citations to cases that don't actually exist. And so we need to remember that we need to be responsible in using AI. We don't file things without actually reading it, verifying, the veracity of certain things that could be easily proven false. Um, so we
One of
need to
the
be
ways,
careful in how we use it. Go ahead, Tom.
Jim, one of the ways that I like to think about using the content from these tools is to treat it like a draft. What you get out of it, treat it like a draft from, say, a clerk or a law student or maybe a junior associate. And if you're going to use the material, if you're going to put your signature on it as attorney, review it like you would, an unexperienced clerk or student. Know what it says, make the necessary edits so that the final product is something that you can say is, your post-review work product.
Yeah, make sure you believe it yourself, right? And take the time to make sure that things are accurate and so on. It's the idea is that it's to help you move in a positive direction more quickly and be productive and create a more thorough, accurate work product. But that doesn't mean that you only spend you don't just rely on what the computer tells you. You use your own knowledge, your own experience, your own prudence to do this. So that's where this comes from. This slide here comes from. AI won't replace you, but the person using AI will, because you're going to be able to generate your work product in a more efficient way, and that can include. That may not mean that you're spending less time necessarily, but it means that you're spending less time doing the things that don't necessarily generate the higher quality work product in the end. I have a slide later on that you'll see that talks about that balance between getting a first draft and getting a quality work product. So that slide will be coming up shortly. So why don't we go ahead and move on from here? So one of the things that Otto can do to quickly update is to quickly update your method claim for different things, or it can quickly update other text. Here, I just chose something, kind of randomly here that was in the context of the invention disclosure, and I asked it to, update the claim to focus more on the overlapping text feature. And so that's what it did. And you'll see right there that, it modified the claim from where it was before. Or I might ask it to make the claim more concise. And in other words, shorter, use less text. And so you'll see it did that very quickly. And here I'll go back. You can see the text, how much text is there. Rather than worrying, too much about the actual detail of what the claim language says here, we can share the slides with you. The slides will be available for download, and a recording of this webinar will also be available for you. But so you can go into the details about what the claim language actually says later. But that gives you an idea.
I think the idea and the takeaway here is that when you get a response out of the system, it may or may not be what you want, or it may or may not have been the direction that you're going. But with a few follow-on prompts, questions, or directions, you might get it closer and closer, so that you can, just with a question or with a prompt, you can save a bunch of time in that drafting process.
And what you can also do is, rather than saying, draft an independent method claim to the invention, you can tell it draft 5 independent method claims. And you can look at the 5, and it does it very rapidly. And you can compare the 5, and you can say, these, which you may not like the direction that some of them are taking, or you may not like the text. So you can get different examples of how to do it, and choose the one that best fits what you think the best, approach might be, rather than just relying, drafting a good independent method claim can take some time. And if you can get some quick drafts, you might get some inspiration in a direction that you wouldn't have taken, may not have thought of, but you can start knocking off that time. Like, I like the direction of this one. And then you may choose to modify it, like Tom was saying, to focus on different parts, or to get the language better, or make it more concise, or, change the direction at which you're claiming from. So it's not doing your work for you. It's helping you develop a better claiming strategy to help do it more quickly, and so on. So then from there, you can also ask it to draft your dependent claims. And so we asked it here to draft 6 dependent claims, to fill it out with 7 method claims. So those are interesting. And then we asked the attorney to generate some, the hidden identity attorney to draft some dependent claims. And so there's 4 more there. And so those are interesting too, those are reasonable draft claims for sure. But here's the slide I was talking about. Writing a first draft consumes approximately 75% of your writing process, while the other 25% is more important for ensuring completeness, accuracy, and overall quality. By embracing AI in drafting your documents, you can transform a meticulous task into a symphony of efficiency. Otto, this is a quote that we received. Otto's like having a diligent assistant who comprehends legal and technical intricacies and accelerates the drafting process to enhance your precision and enabling greater focus on strategy and refinement. So you're shifting time from your initial, blank page to being able to spend more time editing, refining, and so on. It's quite an effective way. So there are a few questions coming in. I'm just going to take a quick peek at those now. One just caught my attention right now. The question was, is Otto continuously trained so that it can keep up with evolutions in patent practice? So Otto, we do update the training on Otto. It does happen from time to time. But it's not necessarily a fully real-time process, but we're working on improving that and quickening that up. So the next question is the tool self-learning. Is it learning as it is being used? And that is a good question. So it has its general knowledge, or the knowledge that it's been trained on, the tool does. When you upload documents to it, the tool will, or when you upload documents, or you can instead paste text into it rather than uploading documents. And that enables the tool to read those documents and learn from those documents, but only within the context of the session that you're in. That learning exists as long as the session does and is used only within that session. As soon as you click the X to delete that session, that knowledge goes away. There's no sharing of knowledge between sessions or between attorneys, attorney accounts or user accounts, I should say, or between customers of ours. It's very segmented out. There's no sharing of data. It's built to ensure confidentiality. And I would say that it's likely even more secure than most attorneys. When you work with one client, you get information in your mind, and you don't flush that information out of your mind when you go work with the next client or the next matter. It becomes a part of your general knowledge. And so there's going to be some bleed through within the minds of attorneys. And it's not intentional by any means, and we're all careful to minimize that. But some of it is almost inevitable. And so within within our Otto tool, the information you upload to it only exists in the context of that particular session. And if you're using a session for one invention or one application, and you're using another session for a different application, there's going to be no cross-sharing or cross-pollination of information between the two. So when it comes to security, we're serious. And when it comes to privacy, we're serious. And so it's great. So let's see. There's a question here. If one wants to implement Otto, what are the technical specs to implement? It is cloud-based. It is not on-prem. The specs to implement, you access it via web browser. And it is in the cloud. The data is stored in the US and it's processed in the US. As far as, let's say, or CA, or Canada. We haven't had a request for anything to be stored or performed in Canada. We're happy to talk to you.
Currently we're all on US servers. And that's how it's set up right now. Like you mentioned, the data lives there during the session. If you have additional context that you want to be considered, say an invention disclosure and prior art references, those can all be loaded into your session context. When you're done and the session's closed, they all disappear. They're cleared off servers. There isn't, I think this might be a little redundant of what you were saying, Jim, but just for clarity, there isn't learning or training that's done from the material that an attorney uses within the system. There is learning that is added to the model generally from publicly available data, as most models are trained. So that, I think that answers a few of the questions that are out there in the Q&A.
Go ahead.
Yeah, and the back end models that we use can vary. So at the moment, we aren't disclosing any specific ones because they may be interchangeable, and if we say one now, it could be different next week.
Yeah. Was that okay? So, there's a question: does Otto consider anything other than the uploaded disclosure when providing output, specifically prior art? It's possible that you can also upload prior art and ask for the claims to be distinguished over prior art. You can do things like that, or you can ask the tool to consider your claims in view of the what is disclosed within prior art references. Or actually, it wouldn't even have to be a prior art reference. It could just be a reference. You can upload anything. So yeah. Okay. So let's see. So we answered a number of these questions. I didn't check them all off. So we'll come back to those. Why don't we go ahead and proceed for now, and we'll come back and answer some more questions later. Okay. So continuing on. So the Showdown summary, we have more to go here, but the hidden identity attorney had great questions, good claims, but to update takes more time, a more time-consuming effort. And after 2 hours, the human attorney did not complete all of the assigned tasks. The Otto AI-assisted attorney, the first set of 5 questions was kind of light, but the next 10 arrived at essentially the same place as the hidden identity attorney. The claims were essentially, I thought they were kind of indistinguishable and were able to update them rapidly. But in fact, our own poll showed that the AI-assisted attorney, the Otto-assisted attorney, generated a claim that it appears that that our attendees here thought was a better claim. So I guess that wasn't the question we asked. We asked which claim was drafted by a person. So anyway, yeah, the AI assisted attorney was thought to be the pure human attorney. So anyway, all assigned tasks were actually completed within 20 minutes, and if you add in another 10 minutes for reading the disclosure, just to be fair, it took 25% of the time to arrive at a place that the human attorney did not reach at all. So the AI-assisted attorney generated very comparable and in some ways superior content. The auto-assisted attorney completed all the assigned tasks and did it in a quarter of the time. So I think that illustrates how powerful an AI-assisted attorney can be. But there's even more than that you can do. So let's finish up the claim set, right? Because this is all of this stuff here that I'm showing you. I'll tell you where it cuts off, was completed within a half an hour. So the next thing was to generate article of manufacture claims. We generated, I can't remember what the full number of claims was here. I think we got up to 15 or so that we generated. Yeah, here, yeah. So we generated about 15 claims. But the hidden identity attorney did not complete within the approximate 2 hours spent on the project. But you can then consider, other things like, do the claims meet the requirements of Section 101? And we received a very detailed analysis from Otto on this, and you may not get the same result when you file the claims at the USPTO, but that's kind of the nature of the beast right now. At the same time, I have submitted claims to Otto that it identified as likely having issues. So you can use this tool to evaluate your claims in view of certain statutory provisions. And you can do the same. Go ahead, Tom.
there's things that you can do to make the best use out of a tool like this, which is rather than asking for like questions with binary answers like yes, no, you could ask it in what ways might this claim run into one-on-one problems, for example. And so then you get the reasoning along with, rather than just a determination that may be right or wrong. And then as a practitioner, you can evaluate that reasoning to see if it's helpful. That's
Yep.
one of the tips that you can do with a tool like this.
Yeah, and even if you do ask it, for a seemingly binary answer, you can then ask it to explain its reasoning. And even if you ask it to do certain things and you're like, yeah, I don't know, you can still ask it, explain your reasoning, even if it's not a, binary answer. And so, yeah, and so this is an example. This next, well, here, we'll go on a couple more slides. You'll see some examples of that. But we went ahead and submitted the claims that were generated by the hidden identity attorney. I guess there's a typo on that slide in the header there, doe. But anyway, the claims from the human hidden identity attorney were submitted to the tool as well, and they were also found to be likely compliant with 101. So that's good to know too. But by quickly evaluating key factors like whether claims recite abstract ideas and if the claims integrate those ideas into practical applications, you can use AI to assist in drafting and filing very high quality patent applications with prior knowledge about whether or not you're likely to pass 101 with a detailed analysis, rather than going through that detailed analysis entirely on your own. You can use Otto to do that. But the question that came in before about being able to consider prior arts in view of your claims, you can do that. You can ask it to evaluate the claims in view of references and combinations of references, and it will give you a reasoned answer. So this is kind of along the lines of what Tom was saying. You can get getting a reasoned answer, or the asking the why. What we asked here was asked for a list of AI technologies that could be used to implement the automated audiobook generation invention. And this can be useful to help you broaden your disclosure, make sure you're hitting all the different angles of different types of embodiments that might be used to implement your invention. So what's important here to note is that if you're working in a technology space that you don't work in all the time, or maybe it's because there's nobody else in your firm who's done anything like it and you're the person, or it's a hybrid technology that kind of overlaps boundaries between, say, biotech and computers, which is kind of a common thing, or electromechanical. So you're having to work at least partially outside a technology space that you're most comfortable in. You can use the tool to start identifying areas that might be able to help you augment your application, or different things to consider, different avenues to approach. And maybe you can then ask the inventor more questions, or you can ask one of your colleagues, or you can do a little bit of research on your own, or maybe the AI tool can help you flesh out greater detail for those areas. Another similar question here, what aspects would need specialized AI expertise? This is to assist you in enablement. What can you rely on a person to have an ordinary and the skill in the art, to know? If my approach on that is like, if there's ever a question what a person of ordinary skill in the art knows in view of what my application discloses, I would usually disclose, right? Just write a few more paragraphs or whatever. But you don't have an objective view. You only have your own skewed viewpoint on that, or maybe you're taking the inventor's word for it. So if you have a sounding board through the AI tool to quickly get an answer to that, or get an idea, you have this hypothetical person becomes, less hypothetical when you're drafting your application. And if you're ever deposed on a certain question, you can say, well, here's the approach I took to figure out if I disclosed enough. And you have an answer to it, rather than I just used my best guess, which maybe is enough. But if you're using an AI tool and you're following a process, you have an answer to that question, and it's a reasonable answer. You're moving in the right direction. Another one, what are some potential enablement issues? You may have a certain view of the world. You may have a certain certain things might be obvious to you on how to do it. But again, there might be other concerns that other people might have that you're not aware of. And if you're drafting a patent application in an area where you've done a lot of work, you've probably lost complete view of what the person having ordinary skill in the art knows and what they can rely on. So having an objective tool here is pretty useful. So another useful thing that is, you want to come up with a good title for your patent application. It might be because you want to steer your application into a certain art unit or away from a certain art unit, but it might just be that you want to be able to, put a good title on an application just for the, notice provisions for searchers. And so you can just ask it, hey, what are 10 good titles? What are 10 title recommendations for this patent application? And they can give them to you and say some attorneys prefer titles that are 7 words or less. So you could tell it, limit the titles to 7 words or shorten these titles to 7 words. And it can do that for you very quickly. And then you can pick and choose which one you like, or maybe you pick part of one and part of another. Put it together in kind of like a hybrid title there. But yeah, and these next few things and everything we've talked about until now, it's really focused on drafting patent applications. But the application of these applications for this tool are much broader. They're very useful when preparing office action responses to summarize references that have been cited, to get reports on whether or not the references teachers suggest what the examiners are asserting they do. And you can use it to quickly find places within documents that might teach away from what the examiner is asserting the document actually teaches. You can quickly get answers to these types of things. And it's not answering the end question about whether or not you should get a patent. You still need to make that decision yourself. Or I guess the examiner does, but the decision on what to argue and how to argue is made by you. But you can use the tool to help you formulate those arguments, find arguments that you might not otherwise have the time to come up with, and put those in your responses and increase your effectiveness as a patent attorney and your effectiveness in argumentation. So there's been a few more questions that came in. Let's see, how are we on time? Okay. Let's see. Maybe we can just scroll through them. What technical areas can Otto handle and which can it not? For example, software versus complex mechanical cases. Well, the tool is very good on software. I don't want to say it won't do your mechanical cases. I think it would be very useful in that regard, especially when you're looking at in a prosecution context. But if you're looking at if your case comes down specifically to the figures in a mechanical case, it's going to struggle a little bit to help you there.
Yeah, and I think one of the things, whether covering that question or there's some questions that are open right now about how to use for office action responses, is not necessarily to think about how do you use the tool to do an entire project like an office action response or drafting complex mechanical claims or specification, but you would use it for doing pieces of that project. So for an office action response, it could be, here's rejection language, here's prior art context, what aspects of this do we actually see in the prior art document? So use it for targeted pieces to then build arguments that you might use in your response. With the mechanical question, you might use it for a targeted question about something that is text-based within that, and you could get pieces of what you're trying to do. Again, remember, this isn't trying to replace all the work that we do. It's just trying to make us practitioners more efficient.
So there was a question about context size. I just answered that. We're currently at a 100K context size, and we'll soon be moving to a 200K. So yeah, so let's keep moving in the presentation, and then we'll come back to some questions here in just a bit. So where are we at here? Let's go one more. Okay, so let's see. Okay, so here we used the tool to draft a summary for the patent application, or for a patent application based on the claims, and it did it very quickly, and it was based on the independent claims. And again, this is something you may choose to edit, but it gets you a quality draft very quickly, and your edits will take less time than drafting it from scratch. Similarly, we had to draft a background section for a patent application, and it did it very rapidly. And again, you may choose to edit it, but I think that is actually a fairly reasonable background section right there. So what else can it do? Note that everything up till there was done within the 30-minute window that I was talking about before. Now, moving on to some other things that the tool can do, we can use it to help each other. We can use it to help ourselves to produce quality work product. If you're a attorney that's overseeing the work product of other attorneys, or you're an in-house attorney and you're wanting to perform quality control or just review patent application drafts quickly and other documents quickly to decide whether or not the instruct your counsel to proceed, you can use it to quickly perform the analysis that you're already doing every day. But these types of things, being able to do this type of quality control is important, especially in these days where, patent budgets, drafting budgets have been under pressure for the past 20 years. They're essentially, looking at the AIPLA economic survey for the past 20 years, you'll see that the client budgets for drafting patent applications have essentially been flat across all technology areas. And so something has to give, right? Because there's been inflation and everything. But at the same time, clients are asking you to do more and more. Using a tool like Otto to help you perform this analysis enables you to save time and do it more quickly, identify problem cases or cases that can be improved in certain ways, or identify the holes in the cases that you're having to work on very quickly because your budgets don't allow you to take more time. Otto can really help you protect yourself and protect your clients, from your own, from the challenges that you're facing. And so one thing might be is, whether or not you want to claim all the subject matter you described. So what I did here is I uploaded the application that we based the disclosure on, and I just asked it, does the application include any unclaimed subject matter? And, there's arguments for claiming every bit of subject matter, and there's also arguments for maybe including some details that you can fall back on during prosecution if you need to narrow the claims to get get past some rejections. But in this case, we identified that there was not any undisclosed or unclaimed subject matter. One other question you can ask: are all the claims supported by the specification? That's a very reasonable question because you want to make sure it's there in every application, right? So it gives you a reasoned response as to why it is supported, but it also you'll note right here, the only potential question is on some of the specific dependent claim limitations reciting more generic computer components. And in these days of 101, you may choose to provide more description there, or you may not. Or if there's something unique about those that isn't being identified, that tells you, hey, I need to go take a look at that and just take and maybe it's fine, but I'll take a look at it and just make sure it is. And if you're looking at are all the words in the claims, do all the words in the claims appear in the specification? While you don't necessarily need to have actual verbatim support in the US, you may want to consider that in view of the claims that you're filing in Europe. But then you get to a point where you need to file a continuation application, and you need to draft some claims that are different in whatever way from the claims that are either currently pending or allowed or about to issue. So you can ask this tool to quickly draft those claims. And the other thing here, like Tom was talking about, knowing the reasoning behind it can be helpful. And so one of the things that I'll commonly do is I'll ask it to explain the rationale or what the strategy is behind drafting these claims. And I might agree with it, I might not. I might ask it to change it and redraft the claims. And from there, you can choose to edit the claims or whatnot. But you can, I'm actually pretty impressed with the output of this. And it happens very quickly. And so, when you have those limited budgets of $500 or $1,000 or $1,500 to prepare a continuation, well, this is going to help you get there in a very cost-effective way, very time sensitive way. But here's an example of something that can be done with a tool outside of just straight patent prosecution in a more general legal sense. Commonly, patent attorneys are asked for non-disclosure agreements, and some attorneys have a copy handy. Other times, inside of firms, you'll see emails going around saying, "Hey, who has a current non-disclosure agreement?" And maybe you need to modify them in a certain way. Maybe you need a feedback clause, things like that. Well, you can ask the tool to do this for you, generate a non-disclosure agreement for you. And you may choose to use it, you may choose not to, but it's a form, it's a template that you can use to modify in however you need to do it. But it gets you started. It gets rid of that blank page of paper. It helps you reduce that 75% of the time that it takes to generate your first draft. And the more you reduce that, the more time you have to edit, refine, and improve your work product to eventually send on to your clients for filing or approval or whatnot. Or if you're able to save time, you can reduce the time to produce the end product that you're attempting to produce for your client. So the benefits are numerous. There's a lot of opportunities to implement the different uses of the tool, and these meet your business priorities. But the opportunities here is that the hidden identity attorney did well, but still fell short in terms of time, at least, that it took the AI tool, the Otto tool, to generate the work product. The auto assisted attorney prevailed, at least in with equal drafting in 25% of the time. But I think our poll results showed us that Otto likely produced a better result, especially considering the time it took. And the assisted attorney not only QC'd its own work, but also the work of the hidden identity attorney, such as, for 101, like we talked about it. And then that remaining time, our AI assisted attorney could scroll through Cyber Monday sales and drink too much coffee. But the business priorities of the firms and your own personal business priorities are facilitated through the use of the Otto AI tool by increasing your productivity while improving your quality, decreasing the time to your first draft while increasing your time available for the other things that you need to do to ensure a high quality work product. Experienced attorneys are likely to see the greatest gains here because they have a keen sense of what's good and what's not good, or what's needed and what's not needed. And a seasoned eye is well suited for prompting, updating, and editing the output of the AI tool. But at the same time, the junior attorneys are able to produce a higher quality work product because you can use prompts to review the work product to make sure that they're dotting all the I's and crossing all the T's. Their analysis is thorough. They're thorough in what they describe and what they enable in their patent applications and so on. So it's a great tool. It works out really well. So Tom, did you have anything there? In the meantime, I'll scroll through the questions a little bit.
A few of the questions covered or were about whether or not you could do fine tuning, or whether this tool is trained just on US, or can it be directed to, say, European style drafting? And I think the overarching answer for that is one, we don't have currently like specific model fine-tuning capabilities. Part of that is because we are very concerned with privacy, and we don't want to use any customer context data as part of the model training itself. Okay, that being said, a lot of what I think folks are asking about can actually be done by using context. So if there's particular styles of drafting, say that you use within your firm, for example, then asking for a question and asking the tool to provide the answer in a particular style, perhaps by providing an example as part of the context, would be one way to be able to implement more, say, firm or personal styles and try and get those more implemented within the answers. They may not come out perfect, but again, they're going to get you kind of closer to the goal line. The other is if you're looking for, say, US versus European style or requirements, one way to try to do that is just to simply ask for the tool to give a response in line with, say, EP requirements. Or if you've got a question about spec support, you could say within the scope of requirements used by the European Patent Office, et cetera, and so on. Without going into fine tuning, you are able to get some of that kind of additional detail built into your answers by using context.
So there was a question about whether or not there's free trials available or a trial available at all. And the answer is yes. We have a limited number of trials available. We're willing to give you free trials through for a period of time. If you're interested in one, you can email us at sales@blackhillsip.com. And I did say IP there because we haven't switched over our email addresses to AI yet. So that's sales@blackhillsip.com. And just ask to be set up for a trial with our AI tool. It's going to be on a first come, first served basis because right now we are limited on the number that we can free trials that we can offer. But if there's not one available for you at this time, if we can put you on a list to make sure that we'll get you one before you sign up with us. But yeah, there are trials available. There's a question too about productivity improvements. What we've been experiencing so far with our customers has been a 5 to 10% productivity improvement. And that's a small data set because this hasn't been out there for a considerable amount of time yet. It's just since October. But so we've been out there for about a month and a half now. But we're seeing tests of about 5 to 10% improvement in productivity. What's key or significant about that really I really keyed in on pretty early is that if 1 month is just over 8% of a year. And so if you're improving your productivity by 5 to 10%, that's shorthand for a month. And 1 month is unique because you think 4 weeks, okay, what can I do with 4 weeks, right? How do I improve that? One, you can make 4 weeks more money. Or two, in view of the budgetary constraints that attorneys have been facing, something's had to give, right? Because your billing goals remain the same, your productivity goal, your profitability goals remain the same, and maybe even have even more pressure on them because of inflation in recent years. Something has to give. So you're either producing less, making less money, or you're not taking vacations, or you're not taking your weekends. And so this is a tool that potentially provides you answers to that. At Black Hills, we say Black Hills AI Freedom Automated, and the tools that we develop, the products that we develop, considering that they've been developed and they're come from the minds of patent attorneys, we have that in mind because we've practiced, we know how it is. The practice can be a bit of a grind, and if you don't get those vacations, you don't get some time away, something's got to give. So we have that in mind when we're developing the tools, and but also to enable you to spend more time on your business development too. Because if all you do is work on producing work product or work product of a high quality, it's going to suck up a lot of your time, and you're going to have less time for business development. So we think our tools are good for not only your productivity and your quality of work product, but also for your quality of life and for further business development. So, okay. Okay, so teach a skill. So when you teach a skill, that gets saved between sessions. That is not saving the information of a session, only the prompts that you want to save. One thing to note here is that starting in early January, we're going to start having a webinar every other week, which is going to be more of a user group where we can get on and answer questions about how to use the tool, what prompts are working, what are we finding, and we can answer your questions. So that is one where we can go into more detail in one of those sessions. Does this have the capability to prepare drawings? There is an ability to generate flowcharts. That is another topic to go into one of the user groups. What technical areas can Otto handle and which can it not? Okay, we already answered that one. If I'm Otto and my client asked me which LLM I'm using, I think we already answered that one. Did you answer that one, Tom? I think you kind of parried that one.
Yeah, it was a non-answer answer.
Okay. All right. So we are at the end of our time. I do see that there are some other questions here. We do have trials available still, like I said. The cost, you know, I think it's going to be a monthly cost for you, depending on the number of licenses that you want to take out for your attorneys, whether it's one attorney or the whole team. That cost can vary. If you want to have detailed or more detailed discussion about that, please email us at sales@blackhillsip.com, or you can email me or find me on Tom or me on LinkedIn, and we're happy to have a conversation with you on that. Can you export the auto results? Yes. Sometimes some you can, some of them you need to copy and paste. If you generate a claim chart, those you can export that in a common separated CSV file and then open that in your in a spreadsheet. The drawings, we're working on a way that you can export a PNG file for that and then paste it into whatever drawing program you're using. Okay, I'll keep answering these questions. I understand we are past our time, but go ahead and, you know, if you need to drop off, go ahead and drop off. So we answered that one live. Let's see. Is Otto trained on specific prompt languages? For example, if you had worded your question differently, would you get roughly the same result, or would you be fighting against training on? Okay, so generally, if you type in your question in different ways, your answer could be slightly different. It should generally be in the same direction, although the actual output could be slightly different.
Yeah, but it's not.
It's
not trained specifically on specific prompts. So like a lot of other large language models, if you put in the same question or slightly different versions of the question, you're going to get different answers that are going to be relatively similar.
So somebody asked if there's a ballpark cost. So you know, I think a good way to think about that is about the cost of 1 hour of your billable time. 1 to 2 hours of your billable time a month is the ballpark cost that we're talking about. But if you have more licenses that you're looking for, then we can, you know, we can certainly talk. But I think that is a good way to look at it. So I think that's all the questions we have. Tom, did you see any others that we haven't answered yet?
Nope, I think that covers it.
Okay. If there's any others, we'll be here for another minute or so. But like I said, email us at sales@blackhillsip.com or reach out to Tom or me on LinkedIn. Happy to have a conversation with you. Happy to give you a private demo, and also happy to get you guys set up with a with a free demo for a little while so that you can try it out and see how you can work it into your practice to increase your productivity, increase your quality, and maybe find a little bit more freedom to do other things. Yeah, so
Yeah,
that's what we have.
stay
Hope you
tuned.
enjoyed seeing it.
Stay tuned. Join the user group. The features and functionality that we have on this tool are evolving every day, so it's really interesting, and there's a lot more to come as well. So we're excited about it.